Welcome to the Top 12 Highlights from Chapter 2. We're looking at the constitutional foundations, and thanks for joining me. Glad you're here. Let's start off by talking about the Constitution. We've got 7 articles. We have 27 amendments, including the first 10, which are the Bill of Rights. We'll talk about in a second. But those first 7 articles, really the foundation, the framework where we get the founders and framers of creating our new government. The Articles of Confederation going away, the Constitution being the new form of government, going to create a stronger central government. First of all, Article 1, going to create a bicameral Congress to balance out the large and small states, and many other compromises along the way that will take effect here in Article 1. We'll also look at how we're going to elect these, or select in the case of the Senate, how we're going to elect the House of Representatives, how we're going to select the Senate, state legislatures choosing senators, and the House being chosen by the people through direct election. Article 2 then looks at the executive branch, the idea of the presidency. We look at the Electoral College, the focus of articles of impeachment, high crimes and misdemeanors that we'll talk about a little later. And then Article 3 looking at the judiciary, the Supreme Court and the federal courts, and giving power to the Congress to determine the size of the Supreme Court, as well as the structure and framework of the federal courts beneath the Supreme Court. So this is really the heavy lifting of the government right here in Articles 1, 2, and 3. Again, designed to be co-equal branches of government, no branch designed to be any more or less powerful than the other, and a lot of checks and balances in place to keep them in check so that they are co-equal branches, as the founders and framers had by design. We see Article 4 here, this idea of federalism, the sharing of power between states and the national government, the role that federalism plays in terms of states and states' rights, in addition to the power of the national government and its rights, and this sharing of power along the way. In Article 5, we see how to amend the Constitution. We'll talk in a little more depth about that as well. The idea of how 27 times we have already changed the Constitution in 233 years, and the process for how that plays down, including the 2/3 and 3/4 columns, 2/3 national, 3/4 states. We then see our Article 6, the Supremacy Clause, the idea that when national and state governments conflict, who wins? It's the national government. How often? Every time. The court case of McCulloch v. Maryland, the idea of national supremacy takes shape here, in the idea that the states can't force the national government to do anything, including pay taxes on a national bank in your backyard. Why? Because of this idea of national supremacy. And you can begin to see the concerns Anti-Federalists are having as to why they wanted a Bill of Rights when you see something like national supremacy in there, or the idea of federalism in Article 4. You can see that the government is changing in terms of the relationship between the states and the national government. So this is critical. And then we get to Article 7, this idea of ratification. Only 9 of the 13 states need to be included need to be on board in approving this in order to ratify. We don't need unanimity like we did under the Articles of Confederation. Not all 13 states need to agree on this. So if we can get 9 of 13, we have ratification. The Articles of Confederation becomes part of history, and the Constitution now is the living, breathing document that the nation will operate under. And then we have the Bill of Rights, the idea of the first 10 amendments to the Constitution. This is including things like the 5 freedoms we see in the First Amendment, the idea of freedom of the press, freedom of speech, freedom of religion, freedom of petition and assembly. And then we have the Second Amendment, the right to bear arms. And no, we're not talking sleeveless shirts, people. We're talking the right to bear firearms. In the Third Amendment, we see the right to be free from quartering troops. In Article 4, the right to be free of search and seizure. In Article 5, the concerns of those that are accused of a crime. You have the right to remain silent. Anything you say can and will be held against you in a court of law. This is the Fifth Amendment freedoms. In addition, double jeopardy. You can't be charged with the same crime twice. In Article 6, we see the idea here in Article 6 and 7 that if you want The jury trial and the idea here that you're on trial, you have the right to a speedy trial, a trial by a jury of your peers, and you need to know what you're being accused of. We see this in criminal cases for Amendment 6, and we see this in civil cases for the 7th Amendment. In the 8th Amendment, we are free from cruel and unusual punishment, which includes excessive bail, depending on how that's determined. Gregg v. Georgia, the case that determined the 8th Amendment. In the 9th Amendment, we see anything that's not enumerated as a national power of government is reserved to the states, and anything not reserved as power for the states is reserved for the rights of the people, individual rights under the 9th Amendment, and we see those reserved powers to the states under the 10th Amendment. So really kind of a catch-all with the 9th and 10th Amendments in terms of trying to outline that. I'm not going to go through 11 through 27, but this is a good list. I'll also give you a bonus list at the end of the top 12 highlights here, which will give you more information on those other 17 amendments, but hopefully you'll find those helpful. Let's move on to item number 3 then, which is this idea of federalism, the sharing of power between national and state governments. Now remember, the idea here was a sharing of power designed to limit national government. They were enumerating or spelling out the rights that the national government had, and that was by design in order to limit their power. If they didn't have something spelled out as a power that they held, then it wasn't a power they could have. It was reserved to the states, and if the state didn't hold that power, then it was reserved to the people. And this idea of federalism was designed to give the national government more power, but limited in nature in that power was enumerated, that power was spelled out. And as we'll see in chapter 3, the idea here is federalism is going to change over time. There's going to be a lot of reading between the lines of implied or inherent powers that's going to shape the role of federalism and the role of the national government as we move forward. But the design of federalism was really to limit the overall power of government as a whole, putting the power in the hands of either state governments or in the power of the hands of individuals back to the people. Notice also that the local government isn't involved here. This isn't a role that the local government plays. So any power given to local government can be taken away because it's given to states. States have that power. States can take it back. And we saw that with the national government giving power to D.C. Because it isn't a state and it's controlled by the national government. When they were mismanaged in the 1990s, we saw that they were controlled by a control review board that basically oversaw all of their issues and their expenses and all of their expenditures. And so this is the role of federalism. This is the role of the national government and the role with states, and particularly as it relates to money, to finances. When we look at Article 4, looking at, highlight number 4, the separation of powers, don't forget about Montesquieu. Montesquieu's idea was here about the idea of separation of powers. We have a legislative branch that makes those laws. We have an executive branch that enforces the laws, and the judicial branch interprets those laws to determine if there is an issue of constitutionality. And they are separate, but they are co-equal branches, and that is by design. Madison loved the work of Montesquieu here in terms of spelling out how to control factions. How do we do that? Through pluralism. How do we use pluralism in our government? We start with separation of powers. We break it up into national and state government, but we also break it up into legislative, executive, and judicial branches. And this is going to keep any one faction or particular group or a group of power from having any significant power over the entire government. They can control one branch of government. They can control one level of government, but they can't control all of the branches and all of the levels all at the same time. And that was by design. We also see here in highlight number 5 the checks and balances, the role that this plays in terms of keeping each branch as a co-equal branch. This is different than separation of powers because it isn't designed to show who's making the laws and who's enforcing the laws and who's interpreting the laws. It's about what happens beyond that in order to keep each branch in check. So the legislative branch basically checks the president by approving nominations that the president makes, by controlling the budget in terms of what the executive branch can spend money on in terms of carrying out or enforcing the law. They can also impeach the president and vice president and remove them from office. Remember, impeachment happens in the House. The removal or the trial for conviction, and which would result in removal, would be held in the Senate. And that is the role that they play. Now, the president president has a veto over the legislative branch, and that is the president's check in the executive branch over the legislative. But the legislative branch can override that veto with a supermajority. That 2/3 override can basically override the veto, and then the bill becomes law without the president's signature. Now, what can the legislative branch do to check the judicial branch? They approve nominations. It's the Senate that confirms those nominees. And then the judicial branch can declare laws unconstitutional to check the legislative branch. Again, to check and balance each other to keep them as co-equal branches. And then the executive branch nominates judges. So that's the check, basically nominating people from your own ideological perspective, from your own policy agenda. And then the judicial branch can check the executive branch by declaring any presidential acts or presidential orders unconstitutional. So again, a check and balance to maintain co-equal branches between the judicial and the executive branches. All of these are designed to ensure that there is a check and balance system in place to keep one branch from becoming more powerful than another. Now, sometimes we have gridlock, this idea of divided government, and we see that with the Senate and House right now. We don't even have to look beyond the bicameral legislature to see gridlock. But we have a House that is a Democratic majority. We have the Senate that is a Republican majority. Or you could look at the House that's a Democratic majority and the White House or the executive branch that is a Republican majority. And so there is gridlock. Not a lot gets done. They're going to have to find ways to compromise in order to move forward. And this is the problem with some of the coronavirus legislation that's stalled in the House and Senate. You have a bill that was proposed by the Senate. The House said no deal. There was a bill passed in the House, and the Senate hasn't even taken it up. This is the idea of gridlock. This is the idea of two parties basically holding a lock on power in different aspects or different chambers, in this case, of the legislative branch. And so nothing is getting done in terms of that legislation. They may be looking at other things. The Senate's looking at approving judicial nominations to the court and has done that. But as far as anything related to the coronavirus legislation, we haven't seen anything like that happen since April. Almost 5.5 months since anything like that has happened. Now, it's very different in a unified government. We had this when President Trump was first elected. We had a Republican House, we had a Republican Senate. Unified government, it's very easy to get things done. Even among the unified government, sometimes there's potential for stumbling blocks. It takes a little longer, especially if you have a very wide tent, in order to get that done. But this is different in terms of how long it takes or how successful a party is in getting those things done. So does partisanship make separation of powers even more of a limit on power? It can. It is possible to limit that power especially when you see divided government. They're going to have to find ways to work together if they're going to get anything done. Otherwise, you're just going to end up sitting there and using the media to send out your message, but basically spinning your wheels and talking to the media. That's going to be your area of productivity more than anything else. You're probably not going to get a whole lot else done. Judicial review, highlight number 7. This idea of determining whether something is constitutional or particularly unconstitutional. Now, keep in mind the judicial branch doesn't look at every law and every act and every order and every nomination in terms of interpreting the idea of constitutionality. But there are explicit powers that the judicial branch has in terms of, because we know that this wasn't spelled out as specifically judicial review in the Constitution, but the idea is here, and we saw that the Federalists were more supportive of a stronger role for the courts, and the reason for that was because it gave the national government more power over checking the other two branches, which ultimately would check that central power of the legislative and executive branches. Now, Anti-Federalists were concerned that it gave yet another branch of government in the central government too much power. They were concerned it would also overrule and override many of the state courts that were also passing legislation interpreting legislation and interpreting roles within the states. So there was some dichotomy there between the supremacy clause, the idea of national and state government conflicting, and the idea of the courts conflicting on the national and state level. So Anti-Federalists very concerned about that as well. And again, reiterating their call for a Bill of Rights in terms of trying to address those individual rights that are enshrined in the Constitution as we see them today. Now, Marbury versus Madison was a significant case, our first landmark case, because it was the idea here of being able to declare a law unconstitutional, particularly this idea of writ of mandamus. The concerns that Marbury had a right to order Madison to deliver the appointment that he was given under John Adams in the midnight appointments before Thomas Jefferson took office as the third president of the United States. These midnight appointments, Madison, as the Secretary of State at the time, looked at this and said, why do we need to issue these appointments? Jefferson's telling me no. I tend to agree with him. Why would we issue these from a previous president? And the idea there, Marbury thinking, hey, I'm getting an appointment, and well, if the president issued these, shouldn't they still have the full effect of the law? And the Supreme Court said no, the new president doesn't have to issue that. Now, Jefferson won the battle, lost the war. Because essentially he won this case, but he wasn't a fan of the Supreme Court getting involved in these matters because he knew that they would then be in his business, so to speak, going forward in ruling on presidential acts, orders, laws, other issues before the court. And he wasn't a fan of that, being more anti-federalist in nature than federalist. The idea was that it was concerning to him, being a very looking at states' rights and a state power advocate, that was of concern to him. So that definitely, that he was definitely glad to win the case, but not necessarily to have the Supreme Court involved, and especially involved moving forward. Now, we see litigation as a significant role being played in the courts today in terms of interpreting the constitutionality, or more importantly, the unconstitutionality of laws, presidential acts, orders, other actions of the government that are being taken. So litigation is probably one of the best ways that we see, especially in the civil rights and civil liberties front, to really get the courts to take action on whether something is constitutional or not. And it is a widely accepted precedent or historical making entity that the Supreme Court determines that constitutionality today. And it's because of Marbury versus Madison that we saw that play out. Now, in number 8, we see the informal methods of changing the meaning of the Constitution. We've talked about how to amend it under Article 5, but there's also some ways to kind of read between the lines. And the founders and framers weren't trying to spell out every method and every possible way that they could outline that the government would basically keep this Constitution as a living, breathing document. And we saw in one of the quizzes where Jefferson talked about the idea of this being a Constitution for the living, not for the dead. The idea that it would change over time, that people would amend it, but it would be done in a cautious and deliberative way over a 2/3 Congress and 3/4 of states, state legislatures or state conventions to do so. So it would be super majorities that were in agreement to make these changes. So, but otherwise, they left a lot of the details to really let Congress work those out. Let Congress, in proposing or approving or proposing legislation that then the states would ratify or approve. And so this process of elaboration is this idea of filling in the blanks, interpreting the implied or inherent powers they have under this. And one of the best examples of this is the Judiciary Act of 1789. In Article 3, the judicial branch is outlined in terms of the role that it plays within the central government. But it gives Congress the power to determine what the courts look like underneath the Supreme Court, and even the composition in terms of numbers of those sitting on the Supreme Court. So they could change the number at any time. And this is the idea of elaboration, the idea that Congress can then fill in the gaps. And we saw with the Judiciary Act of 1789, they were filling in these gaps to determine what do the courts underneath the Supreme Court actually look like? How do those take shape? And what role do they play there? And that's a really great example of how they change the meaning of the Constitution just by using their powers under the Constitution to kind of read between the lines and make some adjustments to that as they move forward. And we've seen that since. But the Judiciary Act of 1789 is still in play. Yes, it's been adjusted from time to time, but we still see the ultimate framework of 1789 still at work here. And this elaboration continues into places like impeachment. What does it mean to say that you are being accused of high crimes and misdemeanors. This is very vague. And we even see senators that from one impeachment to another, from the Clinton impeachment to the Trump impeachment, very different in terms of their definitions and interpretations of high crimes and misdemeanors. So elaboration can, lead to some various aspects of challenge in that trying to interpret this and to play out how that interpretation works within the trial, within the impeachment, within the articles of impeachment in the trial, and playing out in the Senate, the role that it plays there. Because it is so vague, it's really hard to interpret. And so a lot of that is open to interpretation, and we see a lot of it. Now, executive orders and presidential acts, this is the idea that, again, the president can issue acts and orders with the full force of law. They don't need an act of Congress or a bill from Congress in order to make this happen, but these can be determined to be unconstitutional. We saw the Muslim ban with President Trump that I mentioned in the overview video that is just like this. The issue of it being unconstitutional, it was an executive order that was carried out, that was issued by President Trump and carried out by the executive branch, deemed to be unconstitutional because of the way that it was written. There is no religious test for office, but likewise in the First Amendment there was also a freedom of religion, and so what we see here is that the court stepping in. It's not Congress that's doing so, but it's the courts that are stepping in to determine the constitutionality based again on litigation. In that case, it was people suing, saying that they were being unjustly, unfairly, and negatively impacted by this executive order, and the courts ruling it unconstitutional under its current form. Now, they did go back in and change some things and kind of move around some issues to try and avoid another unconstitutional interpretation. But we see that even Congress can step in this role, but we don't see them doing as much of that because, again, it's much harder for them to come to consensus, especially people in the president's political party siding with Congress in doing that. They're not going to want to overshadow their political party leader at the time, which would be the president in that regard. So there are some other privileges that under the executive branch that we see here. In this idea of executive orders and presidential acts, that would be executive privilege, the ability of the president to say, no, these people can't report to Congress on the conversations they have with me because they're too close to me. They work too closely with me. And then it would never allow me to get the advice that I need from my counselors, from my advisors in order to do that. Impoundment of funds. There's been some constitutional congressional check on impoundment of funds. We saw that after the Vietnam War and in the wake of Watergate, in terms of if the president's going to divert funds from a particular area that they're not going to spend money as it was ruled by Congress, then you got to give Congress warning and then give that money back if Congress doesn't change where the money needs to go. And that is a significant role and a change there because of the fact that you are basically taking over Congress's role as the controlling the budget. So that is significant. And then we have the War Powers Act, the idea of can the president send troops? They can for 60 days, according to the War Powers Act of 1973. And the significant aspect here is whether or not that's constitutional. And a lot of that hasn't played out in the courts because neither side, executive or legislative branch, want to know what the outcome is. They're concerned that that will play out too much in the courts, and they don't want to necessarily see the answer. So we move then to the judicial branch and this idea of interpreting the laws, interpreting acts and orders. And we see even the judicial branch is open to interpretation. Again, we saw Congress do this with elaboration. We see the president do this with executive actions and executive orders. Now we're seeing the judicial branch using these implied or inherent powers in terms of interpretation of the law, interpretation of the courts. We saw this in Brown versus Board. We went from Plessy v. Ferguson, in which it was an 8-1 ruling saying separate but equal was the law, to a unanimous decision in 1954 saying that segregation was unconstitutional. In Griswold, we see the right to privacy being established as a penumbra of the amendments in the Bill of Rights, Amendment 1, 3, 4, and 9, as being part of something bigger that establishes this right to privacy that isn't, the words aren't mentioned in the Constitution or in those amendments, but the judicial interpretation at the time in 1965 basically cobbling this together and laying the foundation and framework for what would be Roe v. Wade in 1973. This right to privacy would also go on to help the LGBT community in a number of cases that we see there, including the one that was established with employment non-discrimination under the Civil Rights Act that was ruled just this year by the court, with John Roberts and Neil Gorsuch signing on with the liberal wing to basically establish that non-discrimination under the Civil Rights Act. So a lot of interpretation here happening in the courts, and we see this continuation of this implied powers being expanding the role of the national government through the executive, legislative, and judicial branches. One other thing to note on this judicial interpretation conversation is just the idea of an originalist versus an adaptive, or a strict constructionist versus a loose constructionist. The originalist is Antonin Scalia was a good example of an originalist. The Constitution has fixed meaning, doesn't change over time. What it says is what it is essentially the originalist interpretation. We see him there with Ruth Bader Ginsburg, who recently passed away, and she was more of an adaptive or a loose constructionist. Antonin Scalia, more of a conservative, Ginsburg, more of a liberal. And the adaptive approach is that the Constitution is more flexible, more responsive to the 21st century. And we look at it through that lens. Very different viewpoints in terms of their jurisprudence, how they carry out their votes and their decisions on the court. And so this also changes the judicial interpretation of what we see here. So very significant in terms of the differences in just their interpretations on the court. So originalist, more strict constructionist. We see adaptive, more loose construction. And again, depending on the ruling, depending on the case, can really expand the national government's power or not, depending on the viewpoint and that interpretation. Amending the Constitution, just to recap this then. So we have a 2/3 column, which is phase 1. We have the 3/4 column, which is phase 2. Phase 1 is the national government. This is 2/3 of Congress proposing an amendment, or a national convention. Never happened that way since the Constitution was originally proposed and ratified. And then we see that on the state side, 3/4 of the states or state legislatures can approve or ratify the amendment. And you can see 26 of the 27 times that we have amended the Constitution in 233 years has been through the Congress proposing and the state legislatures ratifying or approving that amendment. The only exception to that was the repeal of prohibition, basically taking back the outlaw of alcohol in the 21st Amendment. That was Congress that proposed that legislation, and it was state conventions that by a 3/4 vote actually repealed that legislation and basically brought back alcohol to the land of the free and home of the brave. So that's amending the Constitution in terms of that. And again, 26 of the 27 times has been Congress by 2/3 proposing an amendment and the state legislatures ratifying that by a 3/4 votes. 3/4 of the states, voting to ratify that. So you need 38 of the 50 states today to make that happen. So how have we expanded the electorate and become more democratic in terms of a direct democracy? Well, we saw in the 14th Amendment, we expanded citizenship to include particularly slaves that were being admitted back to the Union, but also slaves that were in other states, border states and whatnot. So we had a national definition of citizenship for the first time that included all of these individuals. We extend the voting rights to all races, but we know that this didn't include women in the 15th Amendment. So this was essentially all men that could then vote. But we also know there were Jim Crow laws and a lot of other poll taxes, grandfather clauses, and literacy tests that were keeping people from voting, particularly in the South. So while we were expanding the vote, we were also there were also places where it was very limited. In the 19th Amendment, 100 years ago to this year, we expanded the voting rights for women. Women's suffrage became adopted and went into effect. In the 23rd Amendment, we expanded the D.C. vote for electoral college votes. That would be the only vote they have and still have today. That was in 1961. The 24th Amendment eliminated the poll tax, basically giving a lot more rights in 1964 to individuals that would coincide with the Civil Rights Act of 1964. There were some loopholes. Those loopholes would be closed in the Voting Rights Act of 1965 and ultimately in the Fair Housing Act of 1968 in terms of trying to address this. But the idea here is we're expanding the vote by eliminating any barriers to what we see here in southern states that are trying to keep black people from voting. And so these poll taxes were one of those ways where we see that taking place. And by the way, it's questionable now if the felons vote in Florida is readmitting this type of thing by making them pay charges. An appeals court is looking at that now. Hasn't been taken up by the Supreme Court yet. But when the electorate of Florida voted in the last election in 2018, they basically said, hey, people who have paid their dues and gotten out of prison for a felony, they should be able to vote again. And that was by an overwhelming margin that the Florida voters approved that. But the governor of the state of Florida actually imposed paying restitution for their court fees and whatnot. And some of them don't even know what their court fees are. And is this another violation of taking us back to the days of poll taxes? So we'll see how that plays out. But the appeals court has ruled just recently, actually it was just last week, that they ruled that they did have to pay those court fees. And the correlation there is it is a Republican governor that instituted that. And those on the appeals court, many of them were appointed by President Trump within the last 4 years. So the concern there is that are we keeping people from voting who may tip the scale in Florida, and Florida is one of those crucial states in terms of this election, and especially the Electoral College. So we'll see how that all plays out in terms of the 2020 election, but it definitely is an area that is concerning. And then the last amendment we see here in terms of expanding the electorate really was the 26th Amendment, giving those 18, 19, and 20-year-old voters the right to vote. If you're going to war and you've been drafted to go to war, this was right around the Vietnam War at the time, then shouldn't you have the right to vote? You have the right to die for your country, but you don't have the right to vote for your country. And so this was expanded. Unfortunately, I wish I could say that it really opened the floodgates for people 18, 19, and 20 being able to vote and then going out and voting in droves. Unfortunately, we didn't see an uptick or a specifically larger number of people voting, which is unfortunate. And but to close this out, this is the idea of more participation in democracy, more participation in the electorate. And there are some other things that are out there that are still in play, things like banning or abolishing the Electoral College, moving the presidential vote. Again, that would need to be an amendment to the Constitution unless you went with the National Compact, which is this compact of states that say that they will abide by the national popular vote if there are enough electoral votes worth of states that actually sign on to do so. If there's at least 270 electoral votes worth of states that sign on to that. And again, will that be up for constitutional challenge? It remains to be seen. That will definitely be continued in terms of how that plays out. But what we see is a general move towards expanding the electorate, and that's the point of this highlight. All right, I mentioned that I would throw in one more look at the overall amendments to the Constitution. You can pause this part. I'm not going to go over it in great detail, but I thought you might find it helpful in terms of providing a little more guidance on the amendments to the Constitution and the role that those amendments play in the 233-year-old document that continues to live and breathe and change as our nation grows and matures and becomes the more perfect union that the founders and framers envisioned. I hope you found this helpful. This closes out the top 12 highlights for Chapter 2. Good luck on the upcoming assessment, and we will see you back in Chapter 3 as we look at federalism.